Hey, good morning, everyone, and welcome to today's Chet Chat. Today, I'm going to be talking about something that is not very salacious, but incredibly useful. And chances are, if you understand this concept and you're able to effectively articulate it, you will probably benefit from this at some point in your life. And I'm talking about understanding the difference between a penalty clause in a contract and a liquidated damages clause. So, what is that exactly? All right, so I'm going to take you back to it's either first or second semester contracts in law school and just explain the basic concept. In general, a penalty clause in a contract is unenforceable. It's void. It can't be enforced. What is a penalty clause? A penalty clause is a clause in a contract that says if one party fails to perform or if one party breaches the contract, here's what the penalty is. So, one person has a contract with another person to, I don't know, mow their grass every other week, and they put a contract in there and it says or a clause in there and it says if you don't mow my grass or if you're more than a day late in mowing my grass, you have to pay me $500 as a penalty. Okay. That's unenforceable. There are some policy reasons behind it. I won't go into that, but suffice to say, the law in practically every jurisdiction is that people cannot contractually bind other people to penalties because you could see it being a slippery slope. You throw a penalty clause in there and it's you got to pay me $1,000,000, you got to do this, you got to do that. They don't allow that. They do allow what's called a liquidated damages clause. And damages is just the way lawyers say what compensation you're entitled to in the event of some sort of harm, injury, or breach. A liquidated damages clause is appropriate when the actual damages cannot be readily ascertainable at the time of the drafting of the contract. So stated differently, if we enter into a contract and we say, if you break the contract, we don't really know exactly what my damages will be. We don't know how much I'll be out. So let's go ahead and agree on an amount. So an example of this would be, you have a contract with a home builder and, you say, hey, if you breach this contract, if you can't have me in my house by this date, and let's say it's more than 30 days late, we're going to agree that liquidated damages amount is this amount, and that reflects an amount equal to lodging and food, something that would actually compensate me for the specific injury. So a liquidated damages clause, in order to be valid, it has to at least attempt to estimate what the actual damages would be. And I know that sounds counterintuitive because you say, well, Chet, the whole point of a liquidated damages clause is that you don't know what the damages are going to be. And that's kind of where you have to do a little bit of cognitive acrobatics there to grasp that. So it's appropriate when you don't know exactly what the damages are going to be, but you have to attempt to at least try to estimate what actual damages are. So I hope that makes sense. I want to give you an example in real life of how this played out and the resolution. I was moving and we had an alarm company, a security company that we had a contract with. And we had signed, I guess it was a 5-year contract. And we were 4 years into the contract. And we said, hey, we're moving. The place that we're moving to, you guys don't service that area. So I need to cancel the contract. They said, okay, there is a $1,750 early contract termination fee. And I said, excuse me? And they said, yeah, that's in all of our contracts. It's an early termination fee. And now keep in mind, this was not a prorated amount for the number of months that were remaining on the contract. This was just, and they showed me the contract, and it just said, if you cancel the contract early, it's $1,750. Okay. I talked to the person on the phone. I explained to them that this was absolutely illegal, and they assured me that it was legal because I signed it. So that was fun. I won't bore you with the details of my response to that. Um, but basically, I contacted the CEO of the company. I explained the difference between liquidated damages and a penalty. And here's the thing. Here's why it was absolutely a penalty in that case, because the and let me first say this. In their contract, it said, this is not a penalty. This is liquidated damages. Okay? It said that. The lawyers that drafted the contract, they knew this, right? They knew what I'm telling you. But they're trying to take advantage of people. Just because you call something a liquidated damages clause in a contract does not make it so. Okay? No court looks at a term in a contract and says, "Oh, well they called it this, therefore it must be that." No, that's stupid. Okay? That is simply appealing to people who know a little bit, who just know the terms, to hopefully dissuade them from challenging them. When you read cases about liquidated damages and penalties, the courts will say it is irrelevant what the parties call the term. One of the things that they look for in determining whether liquidated damages is in fact a penalty is whether or not the liquidated damages clause is so severe that it would be better off for the person to simply perform the contract. So let's think about this. In that case, if you canceled your subscription 1 month early, and the subscription services are, $55 a month or whatever for security, if you canceled it 1 month early, you'd still owe them $1,750. So clearly it would be preferable from your standpoint to simply go ahead and continue paying the monthly fee. They have it set up where, whatever $1,750 is divided by about $55, it's a lot. It's more. In my situation, it literally would have been better for me just to pay for a full year of monitoring that I couldn't use than pay their liquidated damages clause. And that's exactly what that law is trying to avoid. Okay? So, pay no attention to what they call it. Okay? If they call it liquidated damages, it doesn't matter. You have to look at it. And in that case, an appropriate liquidated damages clause would have been something to the effect of, if you cancel early, you have to pay, say, 75% of whatever remaining balance you have. So if you have 6 months left, you have to pay 75% of whatever your remaining month's fee would be. And that's because their damages are not total revenue, but anticipated profit. So they can't just be like, "Oh, well, you just have to perform the contract. That's our liquidated damages." No, because part of those expenses go to overhead, and their damages would not be total revenue. Their damages would actually be whatever their lost profit was. So they would have to compute what their profit is on an amortized or per customer basis. So something like that would have been appropriate, and I really wouldn't have fought them on that. So anyway, hope that's helpful. One other little nugget of how to escalate these things. If you know that you're right and you have your ducks in a row and you're ready to argue it effectively, if you want to know how to get in contact with people in a company high up, you go on the Secretary of State website and you look up the corporation, find the corporation, and there will be listed the officers and their contact information on there. That's how you look up who the president CEO is. That's where lawyers go to find out who to sue. You find their registered agent for service of process. Okay? That is the person designated to receive lawsuits on behalf of the company. So if you send a letter to that person, now don't do this if you don't know what you're talking about, and just to send an angry, Karen letter like, I wasn't happy, I want to talk to your manager. If you're going to go this route, you better know what you're talking about, and you better be prepared to argue with a lawyer, because that's usually who you're talking to. But if you know that you're right, and you're prepared to, show them that they're wrong. When I sent cases on Florida on the difference between liquidated damages and a penalty contract, and I highlighted stuff, and I basically wrote a memo for them and explained to them legally why they're absolutely wrong, and what a lawsuit's going to look like if we have to go that route. Um, I got a call a few days later that they were canceling everything, and they apologized, and they're retraining their people, and they're actually going to go back and change their contracts and everything. So, but anyway, I know this is a little bit longer video, but this is something that can be very helpful. Be on the lookout for these kind of things. If you ever have to cancel service or cancel a product, make sure they're not hitting you with what is actually a penalty clause. Thanks.